And during that period, the Human Rights Act 1993 was enacted, which substantially increased the grounds on which discrimination is unlawful in New Zealand and expanded the role of the Commission as an advisory role in all rights, including economic, social and cultural rights. From 1994, she was the Dean of the School of Law at the University of Waikato. Then from 1999 to 2005, she was a member of the 9-person International Executive Committee of Amnesty International. She's currently a member of, and former chair of the Managing Committee of a non-government organisation, the Human Rights Foundation of Aotearoa, New Zealand. So if there's anybody in New Zealand who's got the credentials to be able to talk about human rights, this is this lady here. So welcome. Okay.
Let's get you to hold it. See how it goes.
Yep. Paul almost probably come out. Are you ready, Paul?
Yeah, no, good, thank you. Margaret.
What?
Start. No. I'll hold it for you.
You're going to hold it for me?
Yeah, there you go. I'll be your personal microphone holder. That's Margaret.
Okay, we'll see how that... So can you still hear me? Okay, right. Well, greetings everybody. Good evening. Thank you for inviting me to join your discussions tonight. There's certainly a time when there are rather many social, economic and cultural policies in a state of flux here in Aotearoa, New Zealand. So what I'm going to do tonight is simply to introduce a sort of background topic to all these discussions. And it's a topic which seems to be far too little discussed these days, including by politicians, and I'm going to talk about human rights. No surprise there. I believe that human rights, and specifically international human rights law and policy and activism, can provide a useful framework for your future discussions. So, as Robert said, I'm here representing the Human Rights Foundation of Aotearoa, New Zealand. The HRF is a small, broad-based NGO founded in 2011, when we similarly had lots of problems. And its main focus has always been to address those issues which tend not to be taken up by more specific or issue-specific NGOs. So children's groups, for example, or women's groups, or those focused on the rights of people with disabilities or sexual minorities. Now, in recent years, the Foundation's membership and activities have been declining. But we are hopeful to reverse that trend, particularly at a time like this when there are so many challenges for all of us in Aotearoa. And we intend to focus that revival initially on the relevance of human rights in policy or legislative development, let alone any clear commitment to our domestic or international obligations, which seems to be currently lacking to a rather large extent. And perhaps you'll be encouraged to help with that, meaning the Labour Party. So, first a brief word about human rights, because what I'm doing here I'm a little worried about, because because it's not like teaching students where you assume that there's an interest in sub-knowledge before you get there. I may be saying a whole lot of things that you know and have known for years, which is a bit boring. But on the other hand, maybe not. So if you find I'm going over a whole lot of things that you have known forever, just wait. Maybe something else will turn up that you don't know. So, first, a brief word about human rights. When human rights activists and activists talk about human rights, they are using shorthand. Shorthand for human rights and duties in a web of community and concern. Rights wouldn't make much sense otherwise, except as a utopian slogan. Utopian slogans don't have a very good press at the moment, in case you hadn't noticed. And although I'll be speaking mostly about human rights in the legal context, although the law is necessary, it is not itself sufficient to protect and advance human rights. So, sorry. The Human Rights Project, as we will call it, requires also government and NGOs' activity and support. So I've got 3 parts for this talk tonight. And for each, I'm first going to identify the social, economic, cultural, and inevitably political problem where solutions are desperately needed in Aotearoa. And then consider how the international and domestic human rights framework relates to that, and hopefully with some suggestions how that framework might best be utilised. Now, I understand, particularly from the meeting you've just had, that your interest is especially in the right to a safe, clean and sustainable environment. And I will come to that. So that's part 2. But I'm going to begin with an introduction to 2 issues which we all know are crucial to the well-being of many of us, and so to the well-being of all of us in Aotearoa: poverty and inequality. So inequality is if not the core value of the Human Rights Project. It is there clearly front and centre in the 1948 Universal Declaration of Human Rights, both in the preamble and in Article 1, which reads, all human beings are born free and equal in dignity and rights. This unequivocal statement is picked up and amplified in the 2 international covenants which give legal effect to the Declaration. That's in states which have ratified them. That means agreed to be bound by them. So I'm going into legalese. Try not to do that. Thus, the International Covenant on Economic, Social and Cultural Rights, which I'm going to call the Covenant from now on, reaffirms this overarching right to equality. And as its main tool to achieve equality, it is focused on the idea of non-discrimination, identifying groups which have been disadvantaged. And then I've quoted Article 2.2 of the Covenant. So that article, these rights, to guarantee these rights are enunciated in the present covenant, will be exercised without discrimination of any kind as to race, colour, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status, which you would think covers everything, but no. So over time, other categories have been added. see that cunning word, or other status, which opens the door to other things. So in a general comment, which I've listed on the sheet of references, the Committee on Economic, Social and Cultural Rights, that's the UN committee which oversees and monitors this covenant. They were able to include also reference to disability, age, nationality, marital and family status, place of residence, sexual orientation and gender identity, health status, and economic and social situation. So take a while to think of what else might not be there. But there might be something, because this is one of the things you don't see until later, that one particular issue is going to come to the fore. So the international human rights community has similarly long focused on the elimination of poverty. This emphasis can be summed up in the 1998 statement of Mary Robinson, then the United Nations High Commissioner for Human Rights. "I am often asked," she said, "what is the most serious form of human rights violations in the world today? And my reply is consistent: extreme poverty. Not war, not revolution, none of these things, extreme poverty." So the committee, that's the one I referred to before, in a lengthy statement adopted in 2001, refers to a sustained focus on eliminating poverty. It stressed that poverty is not only about income poverty, but that it is a catalyst for many other deprivations. And I've included that statement, I think. Although poverty in itself can be seen as a violation of human rights, it is also the sum of a violation of a range of other rights, which brings us neatly to the economic, social and cultural rights enshrined, as I said, in both the UDHR and in the Covenant. And those rights in the Covenant are work rights and the right to social security, the rights to health, education, an adequate standard of living, which includes housing, food, clothing, and water and sanitation, and to take part in cultural rights, cultural life. Now, in New Zealand, as you may or may not know, we have a dual system. That is, such international rights must be recognised by domestic implementation in a statute to be binding here. We've signed up to the Covenant, but it's kind of, it can be referred to or not, and not is commoner than referred to. There's cases about that. And legal protection of these rights is limited to some specific pieces of legislation, particularly around work or tenancy rights, and with these a few institutions, the Tenancy Tribunal, for example, the Employment Relations Authority, etc. And to the provisions of the 1993 Human Rights Act and the work of the Human Rights Commission. Now, internationally, these rights are required to be reported on and monitored by UN systems, even though they're not necessarily, as I said, in our law. And work rights and the right to social security enjoy the protections of the International Labour Organisation, of which New Zealand was a founding member. We seem to come and go on whether we remember this or not. But crucially, in marked contrast to civil and political rights, none of these are included in the New Zealand Bill of Rights Act 1990, our premier human rights document. There's a long and interesting history about why the economic and social rights are not included in the Bill of Rights, but we don't have time for that, really. Now, all the areas where utilising this human rights framework could be helpful are in crisis in Aotearoa. I know you're not supposed to say crisis unless it's a crisis, but I think they are all crises at the moment. So there have been numerous reports over the last few years, and in some cases decades, outlining the problems and recommending solutions. Take for recent examples the 2019 Welfare Expert Advisory Report, the suggested reforms of the Tax Working Group, those of the Human Rights Commission on Housing, the annual State of the Nation reports of the Salvation Army and the Auckland City Mission, and the tireless activity of CPAG, that's the Child Poverty Action Group. So, yes, I went straight off to the acronym, which is not helpful. Now, there have been some recent reforms and legislative changes brought in by the previous government. So examples include fair pay agreements, which eventually, whoever was thinking that had taken a long time, eventually did see the light of day. Amendments to the 90-day rule, smoke-free legislation, larger increases in the minimum wage, attempted restructuring of the health and infrastructure systems, all of which, incidentally, are being repealed by the coalition government. Some of these reports have made brief mention of the relevance of the human rights framework, but most make no reference to human rights at all, which is a bit depressing for human rights people. Yet there is a wealth of material from UN agencies and a range of NGOs which discuss the content of these rights. They also discuss who has responsibility for their delivery and provide many, many examples of successful implementation methods. There's all this stuff, libraries out there, which you as a political party could make use of. So the HRF has long been campaigning for one particular solution, which we argue could prove helpful in all this situation. The inclusion of these economic, social, and cultural rights in the Bill of Rights 1990. We have proposed this in the 2015 Constitutional Review, which, as you may recall, was never implemented, as well as in international forums, reporting to the Committee on Economic, Social and Cultural Rights, and in the Human Rights Council's UPR, Universal Periodic Review process. Both of these have strongly recommended this change to the government, but so far to no avail. It's quite a long time, 10 years. I'm just adding something else here, which is we have also recommended that the Bill of Rights be strengthened in various ways, for example, by being entrenched so that it overrides individual statutes rather than the other way around. It's not called a weak Bill of Rights for nothing. And this brings us handily to our second topic, the right to a clean, healthy and sustainable environment. and I'm going to call this the environmental right for short, because I tend to forget which bits are in the actual one. Now, the case for legislating this right and legislating it into the Bill of Rights is somewhat different from the one I've been talking about, in that it is not part of the original human rights foundational documents, not in the UDHR or the Covenant. But the United Nations High Commissioner for Human Rights had long proposed that states should treat this right as a fundamental human right. And in October 2021, the Human Rights Council agreed to so recognise it, and this decision was endorsed by the UN General Assembly on the 28th of July 2022. The right to a healthy environment can be seen as underlying all other rights. A life of dignity cannot be enjoyed without the ecosystem services provided by the natural environment. It is the fundamental basis for life's needs. So this final decision has come as the culmination of a long history of lobbying and activity by NGOs and academics. It has been increasingly recognised in regional and domestic instruments and reflects the valuable work undertaken by United Nations agencies. Is that right? At the international level, the principle is also present in both the Stockholm and Rio declarations, to which New Zealand is a party. And the statistics suggest that New Zealand is now in a minority of some 15 states out of the 93 in the United Nations that do not in any way recognise the human right to a healthy environment. It's a bit depressing, isn't it? There is a strong body of evidence indicating that constitutional entrenchment of environmental rights and responsibilities contributes to stronger environmental laws, increased enforcement, an enhanced role for citizens, and improved environmental performance. A constitutional right to live in a healthy environment could have a transformative effect on Aotearoa. New Zealanders would have a greater role in making decisions that affect the environment, their health, and their communities. Governments and industries would be accountable for any failure to respect New Zealanders' right to a healthy environment. It is also striking that New Zealand's constitutional human rights framework makes no reference to environmental issues, especially considering the integral role that respect for the natural environment and kaitiakitanga, the role that these play in New Zealand's national identity. So just a brief addendum to this. There have been two recent positive developments here. The Supreme Court has held that Mike Smith's environmental challenge to several high-profile companies can proceed further. It's not on the list because I lost trying to find where it was, the name of it, but there's a case which you can look up. And James Shaw, I know he's from another political party, has announced he is bringing a private member's bill to include the environmental right in the New Zealand Bill of Rights. Can I go on?
Yes.
Okay. We now come to our third topic. This is called business and human rights. The activities of business are an all-consuming topic here in Aotearoa. Pages and pages in the Herald every day. But rarely are they considered, the activities of business, in explicitly human rights terms. Really is quite polite there, to be honest. The human rights discussion is mostly focused specifically on efforts to make international companies and increasingly national companies, to make them not only responsible but under a legal obligation to protect and advance human rights. So all of this I'm calling business and human rights for short. As early as the 1970s, United Nations and human rights NGOs were exploring ways in which companies might be obliged to observe human rights standards and to be held accountable for human rights violations, especially including in their supply chains. These early attempts were quickly stifled, particularly by corporations in the United States, using tactics not dissimilar to those we have recently witnessed here in Aotearoa by tobacco companies, for example. One of the difficulties in this proposed treaty, and which is often raised as an objection, is that an objection to international regulation, is that the international system of rights and duties has always been entirely centred on the obligations of states and not on any variety of non-government organisations. So holding companies to account requires adjusting this international system to one which can place obligations on at least one section of what are called non-state actors. So another example would be those who are in actual control of a territory but are not a state. So I could give you some examples of that. Meanwhile, other methods, of course, have been used to rein in corporate activity: ethical investment, consumer boycotts, protests. We've had two recent examples of possible government intervention here: the moves towards a Modern Slavery Act and other possibilities to prevent the exploitation of migrant workers, currently headlined in the Herald most days. But United Nations agencies, academics and activists have continued their efforts to produce an acceptable international treaty, which would be binding directly on corporations which signed up to it. And you can find all the details of the progress and current state of affairs concerning this treaty on this website. It's called business-humanrights.org. And there you'll be able to find you'll find all you ever wanted to know about this saga and much more. I do not actually know, because I don't have all the connections that I used to have once upon a time, I don't actually know what the position of the New Zealand government or the Ministry for Foreign Affairs and Trade or any political parties is on this issue, but it would certainly be worth keeping an eye on it. And I'm sure you could find out. I could phrase the question for you. Now, there are inevitably a number of other important human rights issues which I haven't addressed. One of them, in the adequate standard of living, is the right to food and food security. And for this situation in Aotearoa, you need go no further than the 2024 Salvation Army State of the Nation report. And internationally, it's all discussed in the covenant references that I've given you before. One of the others I haven't talked about is hate speech. Hate speech is a prime example of the need always, which I haven't talked about, to balance different human rights in most circumstances. There are very, very few human rights that are absolute, not ever to be balanced against something else. Climate change and human rights didn't directly address that either. Despite the potentially devastating effects of climate change, pollution, environmental destruction and loss of biodiversity on almost all internationally recognised human rights and the values which underpin them, these two disciplines have historically operated for the most part in separate silos. Any practical assistance which such a linkage could provide has also been ignored. But that has all now changed. There is a wealth of material from the UN and other human rights agencies. And I've cited, a bit like the Business and Human Rights website, there's one called the Centre for International Environmental Law, CIEL. You go there and you can learn anything you ever wanted to know about that. Now, the final thing that I haven't talked about is treaty jurisprudence and approaches, and that's, I mean, I have opinions about this, but I'm not qualified to speak about it, really. There's just one thing that I noticed, that a particular document, the 2019 Welfare Report, mentioned as its framework a list of Maori values, Matarangi Maori. I mean, the whole report is structured around those values. And although they are not mentioned here, it would be an interesting exercise, which I might try and find a partner for, I think, to align a similar list of the human rights we have discussed with those values. And it would be especially valuable with regard to health and environmental reform, in addition to welfare. Interesting correspondence. So after all that, I have two recommendations really for your committee. The suggestion that economic, social and cultural rights should be included in the New Zealand Bill of Rights, and that the Bill of Rights itself should be strengthened. Beginning to be quite a lot of cause for that. And the other thing would be doing a human rights check on all policy and legislation. Not difficult. Now, neither of these is a silver bullet, but you could try it. Thank you.
Right, thank you. Questions?
Thank you, Robert. Thank you, Margaret. I was really interested to hear you talk a little bit more about Mike Smith's case. So he's taken the 7 major emitters in New Zealand to the Supreme Court. And I was just looking up what he said. He said it's our duty to protect the future for our children and our grandchildren. They're entitled to be on this earth and to live safely. And that, to me, seems to connect to the UN Declaration on the Right to a Sustainable, Safe... Yeah. If we, if our government signed up to that, it has signed up to that. So will that strengthen his case in the Supreme Court, do you think?
What exactly did you mean that they've signed up to?
Well, the
COP20, or the COPs?
Yes, no,
Sorry.
The Declaration of Human Right to a Safe and Healthy Environment was passed at the UN unanimously,
Yeah.
including New Zealand.
Yeah,
Okay.
that's right. Yeah,
So New Zealand has internationally signed up to it, but
Yeah.
as you pointed out, it's a dual system,
yeah,
and it needs ratification,
yeah,
and there's no ratification.
that's right. Yeah. And so the case in the Supreme Court that you've just quoted, what was happening was that the opposition were attempting to have it thrown out at the initial stage, saying there's no case to answer here. And that's gone all the way up to the Supreme Court, and they've said, yes, there is a case to answer. So now it has to go back again, and then the proper merits of it will be decided on. And with any luck, that will be that he can go ahead. I mean, he's now able to go ahead with a case and bring all his evidence, etc.
And will that include, will that strengthen his case that New Zealand has agreed to that?
Yeah. Yeah, it would just strengthen the whole area around environmental protection and climate change. Yeah, is what I meant. Mm.
David? So the dual system we've got, I'd like to understand a little bit more about the legal basis for that. How come we do have this dual system, and do all countries have the same?
Microphone running.
Okay, so some countries don't have a dual system. Once they sign up to an international treaty, it's law in the country. Mostly common law countries like New Zealand, Canada, the UK, the US, they have this dual system where you have an international agreement. See, we've signed up to, let's take another example. We've signed up to the Committee Against Torture. So, okay, we've said torture's a no-no, one of the few absolute rights, I think, no balancing there. And in order for that to be effective in the courts in New Zealand, we, can't remember, it might have been the national government, but anyway, whoever was then in power, passed the Crimes of Torture Act, which means you can now, bring a case under that act, and of course, by, any decent person running the case would be citing all the other cases under the Torture Convention. So that's how it works. However, there are cases, particularly Lord Cook, one of our greatest jurists, Robin Cook, in a famous case said that he thought that he could quote the Torture Convention anyway, because otherwise it looked like we were just window dressing by signing it up at the international level. It couldn't be used here. So he was trying to bypass this for the time being, but it's still better to have a statute.
So there's a constitutional issue there, isn't there, that works on precedent?
Yeah, that's right. And it's because of that, really, that the common law jurisdictions. But a country like France, for example, it goes straight through from international to national law.
Okay. So is there a case for pushing for that constitutional change in that?
I think that, I think that's quicker ways to get stuff done. Mm.
My question is about the international human rights law. And do you think that in future international human rights law or international law will recognize environmental refugees, and what is the role of New Zealand in that? Environmental refugees or climate refugees? Yes.
At the moment, I'm a bit anxious here because I'm not sure I'm up with the latest thing. But even though I used to do the refuge, anyway, I don't think at the moment that the courts have generally wanted to accept the idea of climate refugees, but I think that is going to, I mean, this is becoming such an issue at the COP discussions, and particularly in our area in the Pacific, that I think that's going to change pretty fast. The trouble is, I mean, there was a case tried in New Zealand by people, I think it was, this is where I haven't honed this up, I think it was Tokelau. I mean, some of you probably know this, but where they tried to claim that they were refugees because of the climate, and it didn't succeed, but I think that's definitely a quick, I think I'm right about that. So anyone else in the audience who can tell me about that?
No, I don't. This is just specific. It wouldn't be Tokelau because they're New Zealand citizens already. So I think it was Tuvalu Kiribati.
Okay, perhaps could I ask a question? One of the recommendations you have made is that the existing Bill of Rights include social, economic and cultural. Okay, so that's one recommendation that we could pick up for our party. The second question comes back to the dual thing. I mean, how do you in fact then make sure that the Bill of Rights takes precedent over all the other acts that are really wishy-washy and whatever in many cases? So there's a second, in addition to changing the Bill of Rights, there is another law change that says the Bill of Rights takes precedent over the others, okay? Has your New Zealand Foundation or whatever got any drafts about what law should be, what that could look like?
I think there must be drafts in existence because this argument was raised by quite a lot of organisations when we did the constitutional review, that the Bill of Rights needed to be strengthened. And it's always been referred, as I said, to as a weak Bill of Rights, and that's because any statute can override the Bill of Rights. So there is an article in the Bill of Rights which says that the Attorney-General has to report to Parliament that if this law is passed, it will be in breach of the Bill of Rights. And Parliament goes ahead with it anyway, and you can't do anything about it. So it would be to reverse that position. And so to take a recent example, or current example rather, the urgent, I was going to say goings on, the urgent activity in Parliament to abolish the smoke-free legislation could be challenged under the Bill of Rights if it was so entrenched by citing the right to health, which would then be not only in the Covenant but in the Bill of Rights, because there is heaps of, I mean, it's not that I'm obsessed with the Herald, but I do like to just potter through it, and there's been everybody who knows anything about it has said this is going to be breaching people's rights to health. So that's a really good example of you could stop it. I'm not quite sure, because I'm not an expert on parliamentary procedure, but I don't know if you could do that I mean, you'd have to be pretty quick off the mark to do that when they're passing it under urgency.
Paul, how much longer have we got?
About 4 seconds.
4 seconds, okay.
Oh, sorry, Tony's got a question. Get your questions in.
I hope this question is relevant. At the beginning of your talk, you mentioned the words child poverty and inequality. Max Rashbrook, in Too Much Money, and Thomas Piketty in Capital in the 21st Century both suggest that redistribution of wealth is the key to ending child poverty and inequality. They also mention that there's about to be a massive transference of wealth from the baby boomers to their adult children and grandchildren by way of inheritance. We don't have a capital gains tax, we don't have death duties or inheritance tax, stamp duties or a wealth tax in New Zealand. So could you just comment on the redistribution of wealth as a means to ending those two iniquities?
So this is a slightly more personal note, because I'm not an expert in economics, as people have remarked to me on occasion. So I'm what is called, I think, an old-fashioned socialist. And so I would think that anything that results in some redistribution of wealth would be a good thing. And all of those people that you mentioned, writers, would say the same, I think. So we could have a capital gains tax, we could have a wealth tax, we could have an inheritance tax, we could have, and some of those were recommended in the report from the tax reform group, whose name I've now forgotten. But again, nothing's been done.
Thank you for the lovely presentation. I was wondering about the unintended consequences of the building up of rights, because one of the things that I have often heard raised is the issue of the right, bringing in things like a right to property in that area and eroding the rights by making it subject to a value set that means that we end up flip-flopping every time there's a government in terms of what those rights are. Would you like to comment on that risk of opening up rights to the Bill of Rights, extending it to these other rights like rights to housing, that there might be a risk that the right retaliate or use that tool to extend to things like the right to property to actually counter the sorts of things that Tony's just talked about?
So, what I've been talking about are the rights that are in the two covenants, and that is all ones that have been added with long thought and difficulty, like the environmental right. Those rights don't include a right to private property. There is a concept of property. I'll just confuse things if I go on. There is a concept of property in some of the comments of the Committee on Economic, Social and Cultural Rights, but it's property in a much broader sense, which includes things like right to artistic endeavours and right, that sort of thing. It doesn't mean doesn't mean private property, so you can have 10 houses. You know, that's not. And so what we put in the Bill of Rights, what's in the Bill of Rights at the moment is nearly all the rights that are in the other covenant, the civil and political covenant. And those are much better protected in New Zealand. And that's resulted in problems. That wasn't a very coherent answer, I think.
So where's Paul? How are we off for time?
We're good.
Okay.
Plenty of time.
Okay. More questions?
Close it up. It's up here, you've had one. So I think, we're coming to the end, aren't we?
Sorry, we're not at the end quite. Thank you, Margaret. That was really helpful. I just want you to go over that. You talked about strengthening the bill, the Human Rights Bill, and entrenchment is one way to strengthen it, I presume. Does that cover, but also including some of the things you've mentioned. But is there something else about strengthening it that you want to explain?
Here we're into electoral law, which probably Helen could talk about better than I. So if we're going to change the Bill of Rights, this is a constitutional matter, and it needs a 2/3 majority in the House. That's one thing. So it's not something, that you can flip with a simple majority. And I think, so as I say, that would require a constitutional vote. And the main thing is to get it to be a law which overrides other laws. Do you want to comment on that any further?
Yes.
No, I mean, would Helen?
Which is that I'm trying to rack my brain as to the law that went through last term where David Parker added the right to debate or the obligation to debate something that was contrary. It wasn't a Bill of Rights issue, but while we have a standard report of a breach of a Bill of Rights that has to be done independently by the Attorney General now and would be one of the tools, I thought that was an ingenious tool to make us have a debate on it. So while it didn't, I wish I could remember which one it was, but I saw it work too. So it was a real catch where people had to pause and think when they were doing something because it came back before us and there had to be a debate. And I know it's not a lot, but at least it's something where it takes it seriously. And I have issues with anything which overrides parliamentary supremacy, and I think my concerns are probably watching the American situation. Really, it stops a lot of change really quickly, but I think that pausing and being accountable for anything that you do that is a breach of these very fundamental values, that's a step in the right direction. Yeah.
You want to comment on that?
No, it's quite true, because at the moment it's just got to be tabled. But it's still the halfway house, isn't it? If it was entrenched, I mean, should still have a debate. But the debate would only go one way, we hope. Does that make sense? I'm feeling that I'm missing some constitutional points here, which I need a constitutional lawyer for.
So we've got time perhaps for 2 more questions.
I'm particularly interested in tenancy, the rights of tenants, and there are tenancy rights in the Act, the Residential Tenancy Act, but discrimination against tenants as opposed to owners isn't illegal, isn't a ground within the Human Rights Act, isn't a ground for being unacceptable discrimination. Do you have any view on that?
You need Chloe Swarbrick here for this, to be honest. I think where you would get a really lot of good information about this in relation to the right to housing is if you did, in fact, get access to all these international libraries that I've been talking about, because there is an awful lot going on about whether it's a good idea to have ownership and renting, or whether there should be some other system that would make it fairer, which is what anti-discrimination's about, for tenants than the current law allows. So this is a real area where it can be easily worked out to be a breach of the right to housing. But it's more likely to be in that kind of relationship. And we do have laws in New Zealand that's supposed to protect renters. It's just they could do with a clean-up, shall we say. I'm beginning to lose it quite a bit.
Okay, well that might be the time to ask you to thank Margaret. And thank you.
Robert, just pick some flowers.
Yes.
Very nice, on the way.
Okay, and so that's been really good. Our branch has got some remits dealing with the right to a health and safety environment. So that's coming through, and hopefully will be debated in some form or other at the regional conference. So watch this space.
Going to the food hall if people want to come for a feed. Ponsonby.
Also, I'd just like to remind everybody about next Thursday, the 7th, I think it is. Max Harris is talking about the Atlas Network, and some of you might have seen Mihi Narangi Forbes at Waitangi talking to David Seymour about it, and it's. I think it's going to prove to be a really, really interesting discussion, and there's been quite a bit of talk about it. So,
Okay.
Same place.
So,
Yeah.
Thank you very much, everybody.
Thursday.
That's it. Sorry?
Is Max Harris going to be here?
I'm not sure. I'm not here physically.